All rise. The Minnesota Workers' Compensation Court of Appeals is now in session. The Honorable Sean Quinn presiding.
Morning, everyone. Have a seat. All right, today is November 10, 2025. We have one case, Yzermans versus City of Shakopee Police Department. It's our file number WC 256609. In addition to myself, our panel today is made up of Judge Christensen to my right, Judge Carlson to my left. Today's argument is being live streamed and recorded. We would ask that when you present your oral arguments that you speak loudly and clearly into the microphone. I'll also remind you of the timing rules. You both have 15 minutes for your respective arguments. We will give each attorney 3 minutes of uninterrupted time to start. Once those 3 minutes are up, I will interrupt you and ask members of the court if they have questions. As to the total 15 minutes, the burden is on each of you to keep track of your own time. Use the clock on the dais. The light will turn yellow when you have 5 minutes remaining. When your time expires, we may allow additional time if we have additional questions. And if one party is allotted additional time, we will give the other party equal amount of time. The appellant may reserve as much or as little of the 15 minutes. You don't have to tell us how much you're reserving. Just keep track of your time. When you step up to the podium, identify yourself and the party that you represent. Ms. Gerber, you are the appellant. You may proceed.
Okay, thank you. My name is Dana Gerber. I represent the employee, Jaclyn Yzermans, in her case arising out of her April 2011 work injury to her right shoulder. The reason for this appeal is we are asking the court to overturn the compensation judge's finding number 57 when he denied vocational rehabilitation assistance for the reasons being, quote, as she is currently gainfully employed full-time with the Amory School District without evidence of substantial earning capacity differential. However, in this case, the evidence is undisputed that the employee was suffering a loss of earning capacity of almost 30% less than her pre-injury wage. The evidence is also uncontested that at the time of the hearing in 2024, the employee was permanently precluded from returning to her previous occupation as a police officer. With those two uncontested facts, the employee is entitled to rehabilitation vocational assistance to restore her economic status. Secondly, in this case, the employer and insurer have not established good cause to modify the employee's rehabilitation plan as filed under MnStat 176.102 subdivision 8. The briefs in this case really established the facts. There are a lot of findings and factual determinations that are not part of this appeal. I'm going to try to briefly give a little bit of background here. Again, the employee was injured in 2011 working as a police officer. She continued to work as a police officer for the most part without any formal physical restrictions until she left that employment in 2018. The reason for her leaving her employment as a police officer was contested. The compensation judge concluded that she retired for reasons unrelated to her work injury. That was an unappealed finding. Additionally, between 2018, when she left the police force, and 2024, the employee had a number of part-time jobs working mostly for schools and did not receive any wage loss benefits whatsoever. The compensation judge held that during this period, the employee was not in an active labor market. That was also not appealed. However, the compensation judge held that the employee re-entered the labor market in 2024. And at this time, she obtained a job as a full-time elementary school teacher for the school district of Amory in Wisconsin. I want to be clear that this job was not obtained through formal a retraining program under the Workers' Compensation Act. It appears to be some sort of variance in Wisconsin that allows teachers to work full-time without a teaching license. She was working, at the time of the hearing, she was working full-time in this capacity, and she was also actively working to obtain her teaching license. but her earnings were substantially lower than they were as a police officer, even in 2011. At the time of the hearing, the employee's earnings were $56,300 per year. This equated to a loss of earnings when compared to the employee's average weekly wage of $20,000 per year.
All right, Ms. Gerber, I'm going to interrupt you and ask the court if they have any questions.
I do,
Sure.
thanks. Ms. Gerber, good morning. Thank you for clarifying that we're really looking at finding number 57. And before we get more into that, what do you think the standard of review in this case is?
Because there were no facts at issue here before you, it is a de novo review. It's a legal question.
Okay. And then my other question for you is the compensation judge made, it actually wasn't a finding, but in his memorandum that you quoted, he said that she was gainfully employed. What is the difference between gainful employment and suitable gainful employment? And do you think the difference is important in your case?
Yeah, so, and I think that's kind of where the area of law occurred. So, suitable gainful employment, as defined in 176.102, is is employment that is producing economic status as close as possible to that which the employee would have enjoyed had she not been injured. And in this case, because everyone agreed that she was unable to return to her job as a police officer, rehabilitation services were necessary, looking at vocational services to restore a earnings loss of almost $20,000 per year, or a reduction of 1/3 of her income.
And I also just, a practical question, in looking at your exhibit K1, there were several pieces to that rehab amendment, and it included a transferable skills analysis, a labor market survey, an employability analysis. Was there anything in addition to those three things that your client was looking for?
No, at that time, those were the specific services that she was seeking. However, the goal of the rehabilitation was set forth in the R2, and that was to provide the employee with a permanent return to suitable gainful employment. And it had a list of a lot of other rehabilitation services aimed at restoring that vocational those vocational opportunities as well.
Thank you.
And the reason I bring that up is because this is a case where the employer and insurer are required to satisfy the this standard in 176.102 subdivision 8 for modifying the plan. They can't just say close the plan. They have to have or change the plan. They have to have brought good cause under the Halverson decision by the Minnesota Supreme Court to change that plan. And they did not do that. They simply said, we don't want to pay for vocational services anymore. And if you look at the transcript of the hearing, the arguments that were made were this employee's full-time working, it's a good job, she probably can physically do it right now. There's no good cause arguments supporting the request when, as in a case like this, everyone agreed that she was earning about 1/3 less than her income at the time of the 2011 injury.
And we know that earnings and earning capacity are not necessarily the same thing. How would you quantify the difference in earnings that a person would need to show to, and Mr. Ware, I'm going to probably have the same question for you. Is there a way to quantify it, or do you think the earning differential or the earning capacity differential doesn't need to be quantified?
Well, I think that there is a baseline at the average weekly wage in terms of what the employee's earning capacity was at the time of their injury, established by many, many cases. In the context of rehabilitation, courts have found the earning capacity to actually be higher than the average weekly wage. But the average weekly wage should be a baseline to determining what the employee's earning capacity was at the time of her injury. And that's all we were asking for. There was testimony of the police chief, the employer and insurer's witness, for example, that the employee could have expected to have earned raises and have a higher earnings in 2024 versus 2011, which is a normal, typical thing. But we were just seeking rehabilitation services based on what that average weekly wage was at the time of the injury.
And I have one more question and then I'll pass it on. We know what your client's earnings were going to be as a teacher. Do we know what her earning capacity is without the rehab services that have been recommended?
The employer and insurers expert, Susan Grobe, did look at what her earning capacity was, and her earning capacity as pursuant to the employer and insurer's own expert was squarely within what her earnings were as a teacher. So the Ms. Grobe conceded that the employee's current earnings of $56,000 were reflective of her earning capacity when she estimated and opined that her actual earning capacity fell between the range of $45,760 a year and $64,584 a year. That corresponds to an earning capacity differential loss of between $30,000 and $11,000 per year,
Thank you.
according to the employer and insurer's own expert.
The compensation judge made the one finding, 57, that you have on appeal, which basically said you didn't meet your burden of proof. And then he added, without evidence of substantial earning or earning capacity differential. In his memorandum, he says it's premature, and then he says it's premature because she's working. You're probably aware from time to time this court says, well, maybe we can look at the whole record, and maybe there's another way to affirm a compensation judge. Is it premature because the second opinion was offered or was awarded? And so we don't know what's going to happen with her shoulder, so maybe we should wait for that?
Yeah, so my read of the decision, it sort of got those two issues confused. So the employees, the premature nature of it was whether she could physically continue at the job. So in order to deny rehabilitation services, the compensation judge needed to have found that she could physically continue at a job that was both economically and physically suitable. We didn't know if it was physically suitable yet, but we knew that it was not economically suitable because the undisputed factual findings indicated a substantial loss of earning capacity when compared to her pre-injury average weekly wage.
Okay, so regardless of the second opinion, premature is just not on the table.
Right, because her earnings were so low. So even if she could continue that, and that's why I brought the appeal, because if she did continue in that job through 2025, 2026, we would be stuck with a factual finding saying that employment of $25,000 less per year was economically suitable, and it isn't.
So as I understand it, then the issue of physical suitability may still be an issue out there based upon the judge determining it's premature, but the economic status, that's clearly in front of us based upon the differential of $20,000.
Yes. And to deny rehab, you need both. You need both of those factors.
Which brings me to my next question. And within the IBE report that was prepared, this is an admitted injury, correct?
Yes.
And can't go back to doing the work she did at the time of injury. And my question is, the IBE states, by applying rehabilitation statute 5220.0100 subpart 26, coupled with my experience as a QRC, Ms. Yzermans would not be eligible for a rehabilitation consultation or statutory rehabilitation services. That's just incorrect. Or what's your position on that? Is that the law or not?
Well, that's not the right standard. As in Halverson, that would be to whether or not the employee would be entitled to the consult. Here, they're trying to modify the plan, and that's an entirely different standard. You need good cause, and there's specific factors that you have to consider, none of which are present here and none of which were argued in front of the compensation judge.
And as I read the IBE report, it's basically a determination based on COTS that she was released to return to work without restriction way back when. She worked without restriction. She left that job. Therefore, at some period of time in the past, she didn't have any restrictions, could work as a police officer. Therefore, she's not entitled to any more work comp benefits of any kind. Is that a wrong understanding on my part?
That's correct, but that's not what the law, I mean, that's what they were arguing, but that's not what the law would require. So there are a number of cases of the Work Comp Court of Appeals where an employee retired or left their job for reasons unrelated to the work injury, and then later re-entered the workforce, and rehabilitation benefits were awarded when they lost earning capacity.
And again, the determination, at least that I saw, I think they're both of them, but the IME report also supports the fact that she can't return to work as a police officer.
Right, that was an undisputed fact. Okay, are there any more questions?
I'm good.
No, no.
Okay, I'd like to reserve the remaining 2 minutes for rebuttal.
Thank you, Ms. Gerber.
Thanks.
Mr. Weir, when you are ready.
Thank you, and may it please the court. My name is Chris Weir. I'm one of the attorneys that represent the respondent city of Shakopee in this workers' compensation case. We are asking this court to affirm the compensation judge's determination that the appellant failed to show entitlement to the exploration of rehabilitation services as it was premature, where she was gainfully employed, and there was no evidence of a substantial decreased earning differential. This was a determination within the expertise of the compensation judge, and it was one that was supported by substantial evidence and was not clearly erroneous. As the court will see from the record, the compensation judge's denial of the requested rehab evaluation was made on all relevant circumstances. This included the timeline of her injury, her post-injury employment, her voluntary retirement, the post-voluntary retirement employment, the ability to find that sporadic work and then full-time work in 2024, and the potential for advancement in that full-time work, as well as evidence of the alleged pre- and post-injury wages. The appellant asked this court to discard most of those factual circumstances and look solely to the earnings she had with the city of Shakopee compared to the earnings she had for the Amory School District. But our takeaway from the compensation judge's determination from the findings and order is that the timeline in those relevant circumstances really mattered. Before I go in and start clarifying it, I do want to just pause before I get interrupted here and ask the court if they have any specific questions, because I do think most of the questions you'll have focus mostly on these factual circumstances.
Yeah,
Okay,
I'm
go
happy to hop in.
Yep.
First of all, do you agree with Ms. Gerber that our standard of review should be de novo, that this is the application of law to undisputed facts?
I would disagree with that, Your Honor, for two reasons. One, this was an evidentiary finding. Obviously, there was a question about whether the evidence supported this decreased earning capacity, and that was something that was in front of the judge. So the judge had to determine the weight of that evidence in that determination. So it is a mix of fact and a mix of law, kind of a mix of that. So in some parts, yes, in some parts, no. I also say that, with all this, it was obviously the factual determination that the judge had to come to this conclusion, whether there was good cause, whether the facts supported this, whether she was entitled to these services based on the facts and having to go through there. And obviously, one of the big issues here is that within finding 57 is the issue of her gainful employment. And so obviously, if that's an appealed fact issue, that's something that you would have to look at as a
Well, let's talk about that. Certainly, the judge found that she's gainfully employed. My question for you is, does gainful employment prohibit an employee from certain vocational services? And if so, what services does that prohibit an employee from?
I don't think it prevents them from the entirety. I think there's some maybe confusion, but there's no argument here that she's not entitled to any of them, right? When we're looking at the rehab services that she's requested, I mean, the purpose is whether she's a retraining candidate, whether she's going to go off and get some of these things, if she's going to need additional services.
Well, but that was not before the compensation judge, right? It's kind of a precursor to perhaps a retraining. I agree with you, but she's not asking for retraining at this point. It's kind of more of an exploration. Would you agree with that?
Correct.
Okay.
Absolutely.
All right. Please go ahead.
Yep. And so the reason I say that, I mean, that's the purpose, right? And I get it. There is this first step you have to go through and then you go on. But the kind of the basis of why you'd want to explore those is whether or not she could continue in that job. So being gainfully employed at the time and suggesting, hey, I'm going to need these services, there needs to be something more. And the reason
But what about, I mean, there is evidence, and Ms. Gerber talked about it today, and it's certainly in her brief. I was making $75,000 plus or minus in 2011, 14 years ago. Now I'm making, $10, $15, $20,000 less now. There wasn't even discussion necessarily about the benefits. That's a substantial loss of earning capacity. Isn't that true?
Let me kind of describe that. So
Okay.
what I want to do is direct the court to obviously our Exhibit 18. It's Bates number DEF 131 to 143. This is Sue Ann Groby's report dated July 3 of 2024. When the court digs into that report, you will see kind of the basis that she has for showing the current earning capacity. And so just for 1 second here, there's no other evidence of a decreased earning capacity besides Ms. Groby's opinion here. And why I say that is that when you dig in there, she correctly notes that the employee returned to work after her injury, was able to work in that position for 7 years without issue for the right shoulder, no restrictions, no accommodations, passed all of her qualifications. And once she voluntarily retired and go on to take sporadic and minimal employment, by virtue of that retirement, she was voluntarily decreasing that earning capacity. Now, as to the number, when you look at the number, she doesn't say she has this decreased earning capacity because of the shoulder injury. She says it as a couple things. Number one, she has this decreased earning capacity because she voluntarily retired, showing that she could have made more. She also moved to Amory, Wisconsin, to their cabin about an hour north of the Twin Cities. So she was outside of Shakopee in that geographical area. It's going to include a different data set. And one of the things that obviously she points to is that there was nothing in, from the record or her restrictions that prevented her from doing most jobs, right? There's no dispute. She couldn't go back to work as a police officer. Our IME said that. I'm not disputing that here. But what it says in here is like they were using a different data set. It was in a different geographical market within her skills, and that market, that was her earning capacity by Groby. But there's no determination there that the decrease is because of the right shoulder.
But doesn't the shoulder surgery and the subsequent development of the shoulder problems, I mean, even if she did not voluntarily retire from the police department, she then would have had to. So, I mean, so the voluntary retirement certainly affected a whole bunch of things when it was in place. But once she returned to work on her own in 2024, and shouldn't that be what we're looking at?
I don't think so, because what you're looking at is the relevant circumstances for that. We've cited 3 cases in this, in our brief here. I'll go off here. So we have Siltman, we have the Severson case, and I've got Graves. When the court breaks these cases down, you'll see that it's not just a earning capacity differential, lower earning, boom, there it is. What the courts in there have done is they look at the factual circumstances that led to that. And the biggest difference in this case is that Ms. Yzermans did voluntarily retire in 2018 after being able to work for 7 years, make this increased average weekly wage, basically demonstrate her increased earning capacity, and then after 6 years came back to the labor market and based on her preference went out to work as a first grade teacher. Now, that's the critical piece here, is that there's no evidence that she couldn't do that job, and there was no evidence that she couldn't do other jobs. And that's kind of the issue.
So, Mr. Weir, sorry, I might be just a step behind your argument here, but are you saying that there's no evidence to say that her decreased earning capacity is related to her shoulder? You're saying is because of other life choices and not because of the shoulder injury?
Yep.
And is that a finding in the findings in order?
No, Your Honor, it's kind of showing that this is a premature issue. That's the point with this, is that when you have these other cases, what you can see from those is that someone has a work injury, either they're going through school or they're trying to go back to work or they're performing an adequate job search, and they're demonstrating this inability to reach that higher level, showing that need to explore these other services to basically put themselves back into that, into their pre-injury
But isn't that what the injured worker is looking for here? Some services to get her back up to that level that she would have enjoyed but for the injury?
That's what she's looking for, yes. But I think the distinction here is the question of whether she would have enjoyed these without her disability. That's why this is so critical with her retirement, is that again, she's working for 7 years, she's making this money, voluntarily retires, and then comes back to the workforce 6 years later in a different geographical market. And I think when the court was looking at this, it wasn't just saying, well, I'm just going to disregard these numbers. It's saying, I'm going to look at the factors here, and it's not demonstrating to the compensation judge that it was just clear as one number here, one number there, right? They were looking at all the different factors. And that's why, when they're talking about this determination, they're talking about her return to work, her voluntary retirement. And obviously at the time of the hearing, there wasn't a substantial evidence of that earning differential, right? I mean, she was making less. That's an undisputed issue. But at least for the statute, it's not saying it has to be in parity with the prior, right? I mean, we're talking about earning capacity, not actual
But
earnings.
how do we know what her earning capacity is without her present earning capacity in light of her now restricted right shoulder and where she now lives? And certainly you can have a defense, hey, you voluntarily chose a lesser labor market, but how do we know what her earning capacity is without some exploration of that?
I think what the issue here obviously is, we're talking about whether this was premature. And I think what the court was at least focusing on was the fact that she had this gainful employment. And so what the court determined, at least with that, is that that evidence wasn't sufficient to show that she had a substantial decreased earning capacity to entitle her to those exploration benefits.
Well,
That's kind of the point they're asking for.
Sorry, I'm sorry to interrupt you. So let me ask you the question then. The issue of a substantially reduced earning capacity, how would you quantify it? At what point does it become substantially reduced? Because certainly the case law says it could even be the same earnings, but when you're talking about earning capacity, earnings aren't. So again, how would you quantify substantially reduced earning capacity?
Unfortunately, I don't think there is a way to quantify it. Now, I would go back to the same cases that we cited in our brief. And the reason I say that is because, again, in those cases, there was discussion about numbers, right? For example, in Siltman, the guy was making about $5.50 an hour. He would have made $11 an hour in this other position, right? And they were able to see that. But I think the relevant factors in that was the guy was going to school at the time to get this promotion. He had the work injury. He couldn't go back to his normal job. He couldn't go back to that position he was going to go to. And then the facts in that case said, well, he's demonstrated this actual decreased earning capacity. I'm not sure there's a way to actually quantify it, right? You obviously, the best practice would be you get your IVs, you get your expert opinions. So for example, in the Graves case, in that case, you actually had testimony that showed she had decreased earning capacity. You had that piece to kind of help the court quantify, but it was the factual circumstances that showed it. And that's where you have cases like the Syverson case, where the person had the work injury, did the work, an adequate job search. And in that case, right, they basically said, you can't go back to your work injury. You showed us that you couldn't get a job that wasn't physical labor. We're going to have to send you or explore these other services. That's how I think the court
But isn't that what
quantifies
we
it.
have here? You've got somebody who went to, I mean, I get the whole part of when she stopped working for the police department through August of 2024, she lost all those claims, and for good reason. But after that, she has restrictions. She can't go back to her old job. Your expert said this is her current earning capacity. It seems a lot less than what it was as a police officer. Shouldn't that just, you get rehab services? You may or may not get retraining, but that's not the issue. You get rehab services.
So I get what the court is saying on this. And the whole point is this, is that when the compensation judge was presented with all these factors, this timeline, this was the determination they made, is that saying, based on this factors, how they were trying to quantify whether there was an a decreased earning capacity, they said there just wasn't evidence of that on this record.
But your expert provided that very evidence.
So, and that's why I was trying to.
So, I mean, if it's substantial evidence, where's the substantial evidence that there isn't a loss of earning capacity?
So again, when I look at that, there's other factors in Roby's report that actually shows that decreased earning capacity, and it's not a one-to-one. And so that's why I direct the court to kind of review that and what
Well, you're
she's
talking
saying.
about other factors that show why her retirement, her move, but the fact, is there a loss of earning capacity? She says, yes, there is, doesn't she?
She doesn't actually say there's a loss of earning capacity. She says her current earning capacity
Okay.
is that.
All
Like,
right.
I'm not trying to be cute here.
Sure,
but-
I understand. Okay, that's fair. But here it is. Here's what it used to be. How is that not substantial?
It's again, it's when the court looks at the factors and what the compensation judge made that determination. And that's what we're asking the court to find. And to be fair to this court, obviously, and to the compensation judge, it wasn't an outright denial. It was a premature. And we've admitted in our briefs that say Ms. Yzermans' circumstances change, and again, something similar to like the factual scenario where she can't continue work as a first grade teacher, which is not evidence in front of this court, right? Or she's unable to do this or has other experts come in and say this is her earning capacity. If circumstances change, I would assume that's a different question. But at least as what we're talking about with the premature, that's what we have here. And I see I'm out of time, Your Honor. so-
Any other questions from anybody?
I'm good.
Okay, thank you,
Thank you.
Mr. Weir.
You guys still have 2 minutes, right?
Yes, you do. A little over.
Okay. Any specific questions you want to answer before I jump into my last thing?
I'm curious as to your response to what Mr. Weir said about she might, and I'm sorry if I'm paraphrasing this incorrectly, she might have an earning capacity, but it's because of her life choices, not necessarily because of this injury. Do you agree with, you can read that into the decision?
I think you can read it into the decision, but I think it is wrong legally, and that's why I appealed the case. In order to find that someone who is voluntarily removing themselves from their date of injury job, in order to find that that in and of itself makes them ineligible for rehabilitation or makes their average weekly wage irrelevant to determine a pre-injury earning capacity, you'd have to overrule your cases, the Workers' Compensation Court of Appeal cases that hold the contrary. For example, in Budo, Boutto versus U.S. Steel, the Work Comp Court of Appeals case in 2007, the employee was a steel worker earning, I don't know, about $50,000 a year. When he injured his back, he went back to work, worked for a period of time, had a fusion, was working within his restrictions, and then he voluntarily left his job and took a severance. Then he went back to work. He wasn't able to afford his living, and rehabilitation services, including, I think, a retraining exploration, were awarded for him to see if he could make up that loss of earning capacity as measured by his average weekly wage. Average weekly wage is the baseline for earning capacity. If you want to establish a higher earning capacity, you can through testimony of what that wage would look like over time, the employee's benefits, all of that. We didn't need to do that in this case because we had a stipulated average weekly wage and we had employer and insurer's own expert agreeing that her earning capacity was far below that. And an agreement of everyone, even the employer and insurer's own medical expert, that she was unable to do her pre-injury job. Those things together require an award of rehabilitation assistance, and that's why we request that the findings of the compensation judge are overruled. Thank you.
Thank you, Ms. Gerber, and thank both of you for your respective presentations. It's actually outstanding arguments by both of you. The record is now closed, and the court will issue a decision within 90 days. We are adjourned.
Thank you.
All rise.